Good evening, everybody. It's Wednesday night, so that means I'm welcoming you to another episode of Calenda, Attorney at Law, here on the Coalition Radio Network. I'm your host, Calenda, and I'm an attorney at the law firm of Inman and Torgy in Coventry. And as usual, I'll be hosting tonight's show, and most importantly, I'll always be putting the law above politics. And as you know, we've been following statewide and national legal issues here on the show, and tonight is going to be no different. My guest tonight is Richard Southwell, the lead plaintiff in the so-called mask mandate court case challenging Governor McKee and the Department of Health's mandate that all school children wear masks while in school during this school year. The issue has finally reached the Rhode Island Supreme Court, and Richard Southwell is here to discuss the latest developments with me. We'll break down these issues on the case, and I'll just say again for the record, everyone who is watching here, please, if you're watching me here and enjoying the content here on the Coalition Radio Network, please take a moment to like the page where you find a wide range of content with certain topics that will certainly pique your interest. So just give us a like here on the Coalition Radio Network and then follow them on YouTube for all their content. But Richard, thank you for joining me here tonight, and I look forward to having a discussion with you about the ongoing mask mandate case.
Great to be here, and I came here from a parents' meeting of the plaintiffs, and they all sent their holiday wishes to you. I told them where I was going, and oh yeah, we know Calenda, of course, yeah. So,
well, thank you very much, and I appreciate that. It's certainly encouraging to hear. Obviously this has been a much watched case. This has been a case that's not only made local news here in Rhode Island, it's certainly got attention throughout the United States. And it's one that has taken in my opinion, a turn that's slightly odd. I'll call it interesting, I guess, for now, and while we get into it. So, just to kind of give the viewers a little bit of a background, you, along with several other parent plaintiffs, had filed suit challenging the governor's authority to issue the executive orders, which directed the Department of Health to issue mask mandates for all school children, visitors, people who are going into schools, but particularly for your children who are in these public schools, and the authority of the Department of Health to enforce those under their emergency regulations. He filed for a motion for preliminary injunction, which would have prohibited the governor and the Department of Health from enforcing those mandates. And that was overheard over, I believe, a 7-day period in the Superior Court before Judge Lanphier, who ultimately decided that while he did see irreparable harm on behalf of the children for having to be forced to wear these masks throughout the school day, every single day they were in school, he found that amongst other things, that you could not meet your burden of proving reasonable likelihood of success on the merits, and that the balance of the equities did not fall in your favor, while also at the same time chastising the Department of Health for the way they kind of issued their regulations. Would you consider that a fair summary of the events that leading up to where we are at this point?
Very nicely done indeed. Yes, perfect.
So I wanted to let you know that I watched as much as the video as I possibly could. I know Pat Ford was there. Pat Ford, of course, being station management here on the Coalition Radio Network. He was there videotaping most of the testimony that was going on during the hearing. And obviously I've read the briefs that were submitted by your attorney, Mr. Picciarelli, and the state's attorneys from the Attorney General's office. And now there are petitions for writ of certiorari, each dueling petitions for writ of certiorari in the Supreme Court. And we'll get to what that means shortly. But as a parent and someone who's not a lawyer, and I know you did testify as a witness, not only as an expert witness based on your actuarial background, but as a parent, how do you feel going through something like this? I mean, I can't imagine that someone in your situation has been through anything similar as to this legal process.
No, this is definitely a first for our family. It is incredibly frustrating the way the policy, the way we got to court in the first place, just the governor's, I'm going to delegate this and leave it as a local decision until I decide not to. And, I'd said this numerous times, including in court while I was on the stand. The way the state has treated the parents in this and their concerns and the stories that they wrote and the way that they've tried repeatedly to trivialize and minimize what is going on with our kids over a mandate that only applies in public schools, because, everybody knows that COVID doesn't go to private school.
Of course.
And, the state's position has very consistently been, wow, how much harm could there be from wearing a piece of cloth over one's face? I mean, that kind of stuff, it's bad policy, and then it's even worse defense of the policy. So it's incredibly frustrating. We were extremely grateful that someone in Rhode Island government, the Superior Court Judge Lanphier, actually sided with us on the issue of irreparable harm, so that the things that we're experiencing and our children are experiencing and that we're watching our children experience every day, those are actually happening. So we're not making that up. That's not, parental instinct run amok. That's really happening. And then, Pat Ford had a great question, which I would challenge the rest of the media to start asking similar questions of Dr. Alexander Scott a couple of weeks ago when he asked her point blank, why are you doing a policy that's, the Superior Court judge found is causing irreparable harm? And what did we get as an answer or response? Masking works.
Because it
that's
works.
What we always get. Yeah, that's what we always get. So it's been a very frustrating process, but it is great to be around so many families. I mean, we're probably over 150 families involved at this point. 35 of them is named plaintiffs. And, we're all saying the same things. We all validate. It's not one school. It's not one district. It's districts and buildings all over the state. This is really happening. And, the governor can poo-poo it, as much as he wants. Dr. Alexander Scott can continue to tell us that the science is what the science, what she says the science is, but we know better.
Right. And, I can see, even as a lawyer myself, but I can see it from a perspective that you're talking about, that how frustrating it must be to have these concerns, not only as a parent, but just as a citizen of Rhode Island, to be quite honest with you, to have these concerns kind of brushed aside by our I guess our political leaders. I don't have a better word for that at this time, but kind of brushed aside and said that, there really can't be that much, damage going on here. And despite the fact that Judge Lanphier he did find that there was irreparable harm. And I would say that as a lawyer, and I'll give my opinion on this, is that it's very rare for a court, when considering a preliminary injunction, to find that the movement, or the plaintiffs in this case, meet their burden for irreparable harm, but yet, have not met the other prongs of the test, as success on the merits and the balancing of the equities. So I would say that's the first odd stage of this proceeding, and the second real odd stage is now where we're at, where we have dueling petition for writs of certiorari, which are essentially requests to the Supreme Court to consider a case. Discretionary, it's a discretionary decision by the Supreme Court, but to consider a case before final judgment is entered, and there usually has to be a compelling reason to do so. I know that your attorney has filed a brief essentially asking them to take the case. The state filed an objection to that, saying there's really no reason that has been offered by your side to take the case. But then on the other hand, they filed their own petition saying, by the way, please take the case to the Supreme Court on our behalf, because we didn't like the finding of irreparable harm, but we're asking you not to we're asking you not to actually take the case, but only if you agree to take the plaintiff's case. Did I get that right? Because I wasn't sure I read that right, because I don't think I've ever seen that.
Yeah, that's the way we're reading it as well. So you won at the injunction phase, but you decided you wanted to appeal the decision anyway. And as unorthodox as it may be, they're challenging two things. Number one is the finding of irreparable harm, and then they're really taking the court system to task over whether or not it has the ability to monitor their work, for lack of a better term, to make sure that they're complying with the emergency statute when it came to issuing the emergency rule, the Rhode Island Department of Health. So it's the first one makes perfect sense. I mean, you got a governor who's probably going to do something. I mean, this stuff all kind of rolls off the books. It's time limited. So mid-February and early March, the executive order and the emergency rule are going to terminate based on the length of time they've been in place. So what's he going to do at that point? Is he going to come up with an Omicron emergency? Whatever he does, having a history of irreparable harm associated with that policy is not great for him. He's also running for re-election in November. That doesn't look so good either. The one branch of government that we have not mentioned yet in this interview is the General Assembly, the legislative branch.
That's right.
They have been incredibly quiet following the finding of irreparable harm. That is going to change eventually because they're getting a lot of calls from a lot of parents now asking, hey, you guys are going back in January. What's the plan? What are we doing here? We got irreparable harm going on. We got a terrible policy. You guys tried to shut off this executive order, an emergency status, back in your last session, and the government ran around you. What are you doing about that? So it's going to be very interesting to see how much longer they think they can, kind of sit on their hands. And we'll defer to the experts and Dr. Scott in the Rhode Island Department of Health. It's not going to play for too much longer.
Yeah, I would agree with you. At least on a political level, that's going to be untenable for the General Assembly to do that if they were to sit on their hands and continue to do nothing. But, one of the things I wanted to take, and I say this with all due respect to Judge Lanphier, but one of the things I did want to take him to task for in his decision was that he had mentioned that when the General Assembly passed the amendments to the Emergency Management Act, the Emergency Powers Act, he had indicated that there was nothing in there that limited the governor's ability to declare new emergencies based on the COVID-19 virus or any variant thereof. I don't think that was exactly correct, because if you read the amendments, they terminated every amendment with the exception, I think it was 8 of them, which were allowed to go until September 1st. But they terminated the emergency declaration that was ordered by Governor Raimondo in March of 2020. They terminated that during the the passing of the budget, and there were several miscellaneous orders that were allowed to stay. But that in and of itself was speaking from the General Assembly on the emergency or the state of emergency that, as the General Assembly saw it, they felt it was time to move past that. And I think that if you look at the scientific evidence that was presented at the hearing between Dr. Boston and Dr. McDonald, that both testified as experts in that case, it is, I think it's undisputed that the scientific testimony shows that a virus such as COVID-19 is constantly going to mutate. They're going to have all sorts of variants as long as there are vaccines out there fighting them, or as long as people are getting them. This is going to be an ongoing thing, as they are with many different viruses. There's going to be different strains of them. So this is going to be an ongoing thing. So that could not have been, not contemplated by the governor, or the current governor or the past governor, when they were looking at this, if they were talking in part with the Department of Health. Would you think that would be a fair assumption that they knew that this is not going to be the original Wuhan strain variant the entire time, or the Alpha variant? They had to have anticipated that there were going to be future variants of this when they originally had the declaration of emergency, and that had to be part of their thinking. Would you think that's a fair assumption?
Yeah, I think variants have been discussed really since the first wave of COVID started to wane, right? Because everybody wanted to know, so how do we know when it's over? And that's when, the first talk of variants and, this is a coronavirus and it's similar to a cold. So it's always going to mutate and it's always going to exist. And at some point it's going to become endemic and we're going to have to live with it. So this was not a surprise. I mean, Delta was not a surprise. Omicron, for that matter, is not a surprise. And all of the other variants that haven't, that have come along, but not risen to that level of concern. So they knew that this was coming, and they knew, the governor knew exactly what he was doing. He described it himself as an end around. He kind of found a loophole. It's like, well, we'll call it Delta. Okay, but it's still really
Right.
coronavirus, isn't it?
Right. So when we get to
he's been
Upsilon,
allowed to get away with it.
Yeah. So when we get to Upsilon in the Greek in the Greek alphabet, and does that constitute another emergency? I mean, we clearly are now well into the variants, well into the different strains. So I mean, how much longer is this going to be allowed to go on? And I think, to his credit, Judge Lanphier did say that while Rhode Island case law does generally defer to the administrative findings of imminent peril from the Department of Health, he was not willing to give them future bottomless, deference should this matter continue to go forward. So I mean, at least there was a recognition that, he was. I read it as almost like he felt he was hamstrung by the Rhode Island Supreme Court case precedent that required him to give broad deference to the Department of Health in their findings, even if there were policy decisions that they could make that may be more effective, that may be less abusive. I would consider them that, as long as they're rational, have some plausible benefit, that he was required to give those determinations the deference that the court said they had to give them. Is that how you kind of were is that how you read it? Is that how it was explained to you? I mean, I certainly don't want you to get into private discussions you've had with your attorney, but as far as you're concerned.
Yeah, the plausible bar is so low. It really gives them a blank check to do whatever they want. And that hasn't gone well for us as parents. So we'll just leave it at that. The fact that, no study of, cost and benefit of implementing this policy was contemplated. The fact that even after the emergency rule went into effect, they didn't bother to start a formal rulemaking process or try and substantiate what they had done with further research and testing. It was such a knee-jerk response, and then it just wasn't followed through on. And for the judge to say, well, they've got a plausible rationale, so I can't, I've got JD next to my name, not MD or PhD, so I kind of have to give them, based on precedent, I've got to give them the benefit of the doubt. That's tough. That's really tough.
It's tough to hear because, as someone who doesn't, you're not a practicing lawyer. You're not, you don't do this stuff on a daily basis. And I'll be honest with you, it's tough for me to sit here and listen to that because it kind of defies logic, because as a judge, you're supposed to sit there and, as Chief Justice John Roberts has told us, kind of call balls and strikes. It's not your job to make the policy decisions, but at the same time, it's your job to judge the policy decisions in accordance with the law. And, I think what we've seen on a federal level, this is something akin to what they call on the federal level the Chevron doctrine, which is, historically, it's a case on the federal level, a Supreme Court case where, historically, the judicial branch would defer to the executive agencies, their determinations on what the policies and regulations should be, and not second guess them. But in recent years, the U.S. Supreme Court has kind of started to backtrack on that and started to second guess executive agencies' decisions if they did not have they went beyond the plausible rationale decision. It had to be something more than plausible. It had to be something that was reasonable, well reasoned actually, and something that could be based in fact, tangible fact, and potentially law. So on the state level, I'm disappointed to see that they haven't moved to that level of thinking. I think that's just simply because these issues don't come up that often on the state level. It's more of a federal issue where you see these types of issues. But this potentially could move into that area where the Rhode Island Supreme Court could start following the federal trend, which is less deference to the executive agencies and more of true judicial review, and holding these administrative agencies to task as to where they're coming up with it, the basis for their decisions, and are these are there less restrictive means to accomplish the task that they're looking to accomplish.
Well, even beyond, you just look at the amount of power that these administrative agencies now hold. And we'll talk about Rhode Island Department of Health. I mean, they've been running the state of Rhode Island in effect since the pandemic began, so nearly 2 years. At some point, we have to go back to the normal system of legislating laws in the General Assembly, having the executive branch execute those laws, and then the judicial branch kind of monitor the two and interpret them as needed. But we're going to give, any administrative agency a blank check to do whatever they want with the kind of impact that their decisions are having on families across the state for an indefinite period of time with, nothing more than a plausibility test. That has to stop at some point. Like, we can't keep doing this. And again, I'm going to keep taking the General Assembly to task. It is long past time for them to get involved in this.
Right. And I think when I got word that the decision had been issued by Judge Lanphier, I think one of the things that really struck me, and I issued a statement similar to what I'm about to say now, was that this has really moved past a discussion on the medical benefits of what is being done to combat COVID. This has really moved into a political debate, which is unfortunate because, as you've said, the General Assembly has taken little to no action to address these things. The governor is more than happy to continue to renew these states of emergencies and the executive orders. The Department of Health believes they're, omnipresent here in the state of Rhode Island, omnipotent. They know all. They cannot be questioned. We saw the reaction from Dr. Alexander Scott, when asked, why do you continue this when there's, a finding of irreparable harm, and she defiantly looked at Pat Ford and told us all, because masking works. She didn't look at Pat Ford. She glared at him. Yeah, it was a glare of all glares, and it was akin. The way I kind of saw it was akin to when a child is similar when a child asks, but mommy, daddy, why can't I do this? And the mother or dad says, because I said so. That was the equivalent of that answer, in my opinion. So I think we need some clarification from the courts as to just how long the state of emergency can be plausibly justified, considering how long it's already gone on. Because, if we can just continue to declare state of emergency after state of emergency after state of emergency with some baseline plausible reason for doing that, there really is no check and balance at that point. There really is no transparency, because we've seen how many times the Department of Health and the governor have moved the goalposts, or moved the entire football field, as somebody else, I think, had put it. I don't want to take credit for that. I can't remember who said that, but I thought that was a great statement. But it has moved the entire football field to determine when these emergencies are going to end, when these executive orders are going to end, when these emergency regulations are going to end. And we don't get any answers to that. They're going to end when they say they're going to end. And, unfortunately, as an attorney who's been practicing here for 15 years, I don't see many judges who would be typically assigned to hear these cases wanting to jump in the middle of this. We have a fairly new makeup of the Rhode Island Supreme Court that's going to hear this petition for writ of certiorari from both sides coming up, and it's going to be interesting to see where they come down on this. But the two most recent appointees were appointees of Governor Raimondo. Um, I'm not going to say anything that would question their integrity, but one has to wonder whether or not at least Justice Long, who has weighed in on the issues of the emergency powers of the governor. I can say that personally speaking, because I argued a preliminary injunction case with her last year with Max Fitness when they shut down the businesses and the gyms. So she has weighed in on this, so kind of know where she stands. But Justice Lynch Prada, who was appointed by Governor Raimondo, has also taken the bench in the time being. And we still have Justice Sattel, Justice Robinson, and Justice Goldberg, who have been on the court for quite some time now. So it will be interesting to see if there's a dynamic change in how the Supreme Court views this going forward, whether or not they're going to continue their deference, their broad deference to these executive agencies, or whether or not they're going to kind of give these regulations the side eye and say, you've got to give us something more than this. Give us an objective answer as when we can expect these things to change or these regulations to be sunsetted. Is that something you would you would agree with?
Well, it's not even. I think the timing, yes. Like, how long is an emergency? When is an emergency, over? I mean, the word emergency implies some sort of, duration, and a short duration at that. The other thing that starts to jump out at you as time passes is just the inconsistency and irrationality of some of these regulations that are coming out. I mean, how much cover can the courts give the Department of Health on the masking issue when, public schools have to mask up, private schools don't have to mask up? If a child is out in public at a movie theater, at a party, at a bouncy house, they don't have to wear a mask there, unless the business requires it. But there's no regulation there, and there's no regulation on the business to require it. So this is such a patchwork, willy-nilly make it up as you go along and do as much as you can get away with. I mean, the courts, if they let this stand, like I said, it's a blank check. Do whatever you want, anytime you want, the way you want, and nobody's going to ask you a question or, try and have you rationalize it and explain it in a way that makes sense. And, this is, why did they put masks on kids in public schools? Because they could. That's why, or at least they thought that they could, and so far they've gotten away with it.
Right. And I think you make a good point there. Like, we've talked about the low bar that they have to meet for these regulations, but, you make a good point as to the rationality of it. This only applies to public schools, not private schools. This doesn't apply to other places where kids or adults or anybody really is sitting still or is in a enclosed space that, for long periods of time, which is ostensibly the justification that Dr. Nicole Alexander Scott has used in her order that this masking mandate take place. What is the scientific rationale that would say children in a school, public school setting only, are the ones that have to bear the brunt of this, where everybody else does not. Now, the state in its brief seems to rely on the fact that at the time the vaccines were not available to the students under 12, so that was one of the reasons why they had to do that. But that would have been the case in any place where children were congregating in indoor spaces, not just public schools. That could have been private schools. That could have been movie theaters. That could have been any sort of business that would have children. So, where is that rationality cutoff? And I don't think that question has been answered to my satisfaction, at least. And I don't think it's been answered. Certainly, it doesn't sound like it's been answered to your satisfaction or that of your attorney.
No, and the risk that the courts, in my opinion, as a non-lawyer and just a dad, the courts are going to have to step in on this and put down some restrictions. You can't give these guys a blank check because they're abusing it and they're making you look foolish for deferring to them. You've deferred to their judgment. Really? Look at what they're doing. Like, you can't possibly think that's a good idea or that makes sense, and yet you're going to, we'll see which way they rule, but you're going to sign off on that. Not a question, not a concern, nothing. Just let the administrators do what they want. That's every bit as bad as some of the General Assembly responses we're getting. Parents are sending emails, they're making calls, and you've got General Assembly reps saying, well, I'm sure the governor would love to take the mask off the children, but he's got to follow the science, and we've got to defer to the experts at the Rhode Island Department of Health. And, if that's your response, if you're still on follow the science, that's so 12 months ago. If you're still, if you're in a position of responsibility in this state and you're making decisions, you're charged with making decisions, and that's the best you can do, you don't belong in that job, and we got to get rid of you.
100% agreed. And I said, unfortunately, this has become a political issue, and assuming, I'm only assuming this, I have no inside information or knowledge about how this is going to turn out, but assuming it doesn't go your way in the Supreme Court, the last remedy that we, the people, have is the political process in this state, because ultimately these are policy decisions that are being made by the governor, by his appointees, such as the director of the Department of Health, Dr. Alexander Scott, and the General Assembly. We have these people, we have the Attorney General, and it's not just because I'm running for that position, but we have the Attorney General who's being their enforcement mechanism, fighting you tooth and nail in court, being the governor's attorney, essentially, the Department of Health's attorney, essentially, and to the best that I can read, not really evaluating the opinions of the other side and determining whether or not these are consistent with the law, and just kind of asking the court to, stay out of the process, and they continue to make this argument, stay out of the process, courts, because this is a political question. The political doctrine they have cited numerous times, saying that, these are policy decisions and the courts are ill-equipped to weigh in and second guess the administrative agencies and the governor, and this should be left to the political process. They've just essentially admitted that this is no longer a scientific discussion. This is a political decision, and that the courts have no business. Right. And that's an ultimate slap in the face, because they've been arguing this entire time, that this is science. This is settled science. We are basing our decisions based on the studies from the CDC, broad deference to the CDC decisions, the CDC mandates and recommendations. Yet at the same time, they're saying these are political questions that the courts have no business weighing in on. I don't know how you can make those two arguments at the same time with a straight face and say to the people that this is a science-based discussion and we're here to prevent imminent harm from people for going forward. This is really just a political discussion at this point.
Yeah, it's about who gets to make the decisions and who gets to make the rules. And this really started with when I got to Rhode Island 20 years ago. I was always told that the most powerful political figure is the Speaker of the House in Rhode Island, and that we have one of the weakest executives in the country, in the governor's office. And Governor Raimondo changed all that. And, she took control and she never gave it back. And then she handed it over to Governor McKee, and, the pieces were in place. So he's just got to kind of run with it. I don't know that he could change it if he wanted to. I think his agencies, and specifically the RIDO, are effectively running the state, and they have been since the pandemic began. And that has to stop. I think the General Assembly, I know the General Assembly comes back next month. They've got $1 billion or so to spend. And I believe that they think that, dropping a $1 billion money bomb on the state will just kind of make everything all better when people go to the ballot box in November. I don't believe that to be the case. You've got small businesses that suffered under Governor Raimondo. They were all in office while that was going on, and they stood by and watched that. You've got the healthcare workers that were, forced to get vaccinated or lose their jobs. That's going on right now. They stood by and let that happen. Now they're letting, mask mandates go into place, ridiculous quarantine rules. I mean, you could do a whole show on that. I can put you in touch with a couple of parents who are expert on those rule books and the playbooks, but they've sat on their hands through the entire thing and just, we defer to the experts at the Rhode Island Department of Health. Not nearly good enough anymore. You're going to have to make some decisions, engage some critical thinking, or you're going to get replaced.
And that has to be the attitude. And I try not to advocate politically on this show, only because I want the show to be more of an informative legal discussion for those who may not understand the process or who are interested in the process and want to learn more. But I have to advocate in this sense, because there has to be some accountability from our elected officials who are putting these policies in place if there's not going to be any accountability from the courts, because the courts, unfortunately, in Rhode Island cannot be replaced. The judges who are there are appointed for life, absent bad behavior and impeachment by the General Assembly. So they're there regardless, but our elected officials are not. And they're the ones making the policies. So those of you who are disturbed by the policies that are being made and continue to be renewed and being offered these explanations by your state reps, your state senators, the attorney general, the governor, the Department of Health, whoever it may be, your remedy is at the ballot box. And many of you who may be watching this may be lifelong members of the party who is in control here. In this case, in Rhode Island, it's the Democrat Party. And they've been in control for somewhat of in excess of 8 decades, if I'm doing my math correctly. Many of you may be members of that party, but you may have the same concerns that, Richard, you've expressed here tonight, that many of your co-plaintiffs have expressed in their lawsuits, and their concerns that they've made public, that they need to speak up and say, you know what, I may agree with you on these issues, on those issues, but here's where it's got to stop. And if it doesn't stop, we're going to the ballot box and we're going to change. We're going to make wholesale changes. It's the reason I'm running for attorney general, because we have an ability to have somebody in that office to be that check and balance and to push back against the rest of that government, including the General Assembly and the governor, because the Attorney General does not report to any of those bodies. The Attorney General is an independent constitutional office. He's chosen to use that office as the governor's rubber stamp, the Department of Health's rubber stamp in this case. And I think that's been part of our problems. We don't have an effective check and balance here in Rhode Island on these situations, and our government has been so opaque that the people just have been left with an impression of what is it that we can do? What is it? Who do we turn to? Who are we able to go to for redress for our complaints? And the courts have so far been unwilling to do it here in Rhode Island. We know that the governor has been unwilling to do it. We know that the General Assembly, to the extent that they're even talking about it, have been unwilling to do it. With the Department of Health are the purveyors of essentially all of these mandates. So that they're not willing to do it. I mean, they're still going after people from a year ago, trying to collect fines for not wearing masks or not running their business according to the regulations. So we know they're not going anywhere as long as Dr. Alexander Scott continues to remain in her position. So the ballot box is the key. And I would encourage everybody to get involved and make sure that they know, they being our elected officials, know that if this is going to continue, there will be repercussions at the ballot box in November 2022.
Yeah, I think, we keep using the word politics. This is no longer about politics. Politics is about parties and policies and good faith discussions about, how to proceed. This is about a profoundly broken government that has been that way for the last 2 years. And so, the General Assembly comes back next month. You guys can get back to work, do your jobs, or we can get you replaced. if you are if you've ever thought of running for office in the state of Rhode Island, this is your year, because there's a lot of energy around making some changes. And I don't care what party you're in. I don't care if you're in a party. Primary the incumbent. If you're a Democrat and you've got a Democrat, it's a pretty safe bet in this state. You've got a Democrat in your district, primary them and see what you got. And, let's turn some of these people out in the street and send a message, because they've been derelict of duty for the last 2 years, and it has to stop. The government is not functioning the way it should. We should not be having to go to the government, to the judicial branch, to the Supreme Court to get, pretty basic answers to questions about public health policy.
Right, because it's not an easy process, and filing a lawsuit in and of itself is not an easy process. But I can say going to the Supreme Court, particularly on a petition for writ of certiorari, is a daunting process, even for lawyers who do it on a daily basis. And there aren't that many of them in Rhode Island. There are not that many lawyers who make regular practice or appearances in front of the Rhode Island Supreme Court, simply because it's such a specialized and highly technical area of practice that you are lucky that you have an attorney who's willing and capable of doing so. And and I wish you personally all the best of luck when you hopefully get to present your case to the Rhode Island Supreme Court, because I do think it's an issue that needs some finality, needs some real review. And you've got 5 justices there who are capable of doing that. And it's just a matter of, will they do it? And if they don't, I think I agree with you. I don't care what party you're in. If you believe in the representative Democratic government that we have here in Rhode Island, that we're supposed to have here in Rhode Island, and you want to see that continue, you should be primarying the people who don't want that to go forward. And that can exist in both parties, because abuse of government power is not limited to one party. Certainly, it seems to be concentrated in the area of people who already have the elected position and are already in power, that want to keep that power. If you're asking me, my opinion, that's where the biggest problem is. People have become too comfortable with that power, too comfortable with people not reviewing that power, and especially in a state where the power is concentrated in one particular party, without any checks and balances. There's really very little fear from those people who already hold these offices that there's going to be any repercussions. So if there's going to be a year where that changes, I think this is going to be the year for that. I certainly hope so, not only for the benefit of those of you involved in this case, but for my own run myself for the Attorney General.
Yeah, there's a lot of people involved that have never gotten involved before, never been to a school committee meeting, never really paid attention to who was getting elected and what kind of policies were making their way through. That has stopped. And on issues in the past, there might be some passion and heat on it for a period of time, but I think the General Assembly has always been very comfortable that, it'll cool down, it'll be fine. We can just, we can wait this out. But every parent who's putting a mask on their kid and sending them off to school every day gets a reminder every day that they need to get involved, be more aware, and make sure that they show up, not just next November, but in the lead up to Election Day. So that's volunteering for a primary candidates, running for office yourself, if you're so inclined and you've ever thought about doing it. And it's working for, the candidate who's running against the incumbent if we find that they're not doing their job come January.
Absolutely. And
I certainly wish you all the best in your run. So, because I think, I've had some up close and personal experience with the Attorney General's office, and I think there's room for some improvement there as well.
Yeah, I obviously agree with that statement. We've seen a very politicized Attorney General's office here in Rhode Island. It's not new, but it's just gotten worse, in my opinion. So, I think that needs to be one of the biggest changes that we make here in the state of Rhode Island. Richard, we've come to the end of our time, but I do want to thank you so much for giving me your insight and giving everybody who's watching here tonight your insight on this process, and just how daunting it's been, how frustrating it's been, how how it's been for somebody who's never really had to go through this process, how it looks from the inside. And, I really appreciate your insight on that. As like I said, I wish you luck going forward. And, I really hope in my heart that the courts will give this a second look, a more strict look when they finally consider these petitions for writ of certiorari and decide whether or not they're going to go further in this case. So, there's obviously going to be more to come, and I hope you'll come back and join us when and if we get some further developments on this case.
I sure will, and thank you very much for having me on tonight. And the parents that are involved in this all appreciate the exposure and everything that Coalition's done for us as well in terms of getting the words and getting the video out. So thank you.
Absolutely. The coalition has done a great job. I've seen it up close and personal. Pat Ford has been all over this, along with other organizations have been all over this. And I think it's just shining sunlight onto these issues has been nothing but a good thing in the eyes of my eyes. And I think in general, anybody who wants to see how the government really works, sunlight is the best disinfectant for government opaqueness. Yeah. So, I'd like to thank everybody who's joined us in here on another episode of Chaz Calenda, Attorney at Law. You can reach me, Chaz Calenda, at the law firm of Inman and Torgy, which is at 1500 Nooseneck Hill Road in Coventry, 401-823-9200. You can also reach me at my campaign website for my campaign to be the next Rhode Island Attorney General, which is CHAS, CHAS, 4ag.com. You can reach me and get information there about all my upcoming events and all the information about my campaign. And as always, you can catch me here on the Coalition Radio Network on Wednesday nights starting around 8:15 p.m. where we tackle these local and federal issues of national legal importance, and I encourage you to do so here on the Coalition Radio Network. Again, Richard, thank you for joining us, and I thank everybody who joined us here on another edition of Chaz Calenda, Attorney at Law. Thank you for joining us, and have a good